I think to mention item number
18.
I inform on order assignment. Just that for that side.
Okay.
18 months. For that date.
Okay. Password for the day is paid for by Mr. A. K. Datta, counsel for the petitioner.
Similar PR in respect of 26 months.
26. Okay. Here also you're taking consent.
Yeah, yes, my lord.
Okay. 26.
And then I need to
Correction of the order.
Yes.
We are sitting only yesterday. How come the correction?
Yes. The order was passed with yes. The interim bail has been granted at one that should have been
Before appropriate wage. Okay. Before appropriate wage. Okay.
Lordship, I meant to mention about item number 8. I've already started with the academic papers.
Yes.
I need Lordship to attend this time.
Both sides are represented on the prayer made by Mr. S. Suthradan, counsel for the petitioner. List after 2 weeks.
Yes, Lordship.
Special division bench is not taking up. You'll have to move the registry.
Item number 27. I'm praying for 4 weeks of time for filing of the affidavit in opposition.
27. Both sides are represented. On behalf of the respondents, prayer is made. For seeking 4 weeks time to file affidavit in opposition to the matter, prayer is allowed. Affidavits shall be filed at least 2 days prior to the next day to listing, based on the date after 4 weeks. Yes. Yes, next. Which says represented on the ground that the learned counsel holding the brief is out of station for treatment. The magistrate is observed today. Just after 2 weeks. Yes. Okay. On the prayer made by the counsel for the petitioner, both sides are present. On the prayer made by counsel for the petitioner, just after 2 weeks. Okay. And madam, I'm not here to preach, but please correct your appearance. It appears that you just got out of the sleep and you just come here. This appearance, it doesn't look good for the court. Your appearance doesn't look good for the court purpose. It may be good for movies, but I don't know. Your appearance is not appropriate for the court purpose. Relook, go to a mirror, look at your face, and then you'll understand what I'm trying to say. Yes. Yes. Item number 10. What says it in present? Same for the term if considered just after 2 weeks. Yes.
How will I get to item number 6?
6. Same one. Okay.
Alright.
Yes, item number 2.
Yes, you have the one weeks for the time. Okay, let it be 1 week only. But I'll record your prayer. What says it duly represented? The General Status for the Election Commission of India pays for further week's time to produce the voters list of 1966 and 1979 in terms of order dated 15/5/2023. Next bill. Mr. T. Sheikh and the counsel for the petitioner submits that the petitioner is not on interim protection and therefore he suffers prejudice with the prayer for adjournment. Next bill. In the event the Election Commission of India fails to produce the complete voters list in terms of the hearing before record order, Learned counsel of the petitioner is permitted to place his prayer for interim protection on the next date. Based on this, after they give a date after 7 days.
Item number 3. This can be a direct topic. So that is the topic from 1965 to 1989. And it's telling with the details covered by the physician. It's claimed that the grandfather name is Samsung. And grandfather Samsung appears in the year total is 1965. It's year number 21.
Yes, 21.
Samsung and Hazara. Also beginning in the year 1970. Second case in notable screen serial number 22. The name of Samsung Hawk appears here. And Hazara Khatun name also appears.
Yes.
In the year 1979, in same village, Bandara, part number 3. In that serial number 23, which is Hazara Khatun, the grandmother name is there. And the petitioner claims that his grandfather, his father name is Hazara Khatun.
Just a moment.
1979.
No, just a moment. this 1965 voter list is exhibit number.
These do not too big to prepare. One
Exhibit number 1.
page number 38 of the
Just
register.
But then this has to be sent back. Mr. Sharma. Because if you come to page 43, summary of the order, page 43, come to serial number 4. From exhibit 1, it has been ascertained that so and so were citizens of India. So if exhibit 1 is one is admitted, the probability of what do you call serial number 7, he was born in not in Assam or India. There's no reason assigned. If somebody's grandfather is a citizen of India, to say that the son was born not in Assam or India, something not reconcilable.
Establishment rate which is not. I have given coming. This is very well.
No, you see serial number 4, what does it say? From exhibit so and so, it has been ascertained that the OP's grandparents were citizens of India. So there's no dispute. The tribunal is not disputing his legacy. His parentage is not being disputed. Grandfather of so and so is a citizen of India. That is the finding. It does not say that so and so is a citizen of India, but his lineage is not proved. It doesn't say so. Okay, I'll issue a notice and then give him a date.
We are trying to say the other citizen.
Huh?
The exhibit 3 and 7 indicate that this father probably one son of
Our grandparents.
comes to work. And who is in the son of someone who is in the
Right. Mr. Election Council for the question. Mr. AI Ali, done it. Council for the Election Commission of India. Mr. G. Sharma, done it. Standing Council for SC border. For correspondent number 2 and 4. For CGC, you will be appearing? 1 and 6, Miss. CGC appearing for respondent number 1 and 6. For 3, government, you did that. And Mr. N. Abhi Sharma, government will appearing for respondent number 3. Additional senior government will appearing for respondent number 3. Next. the opinion dated 16/6/2022 passed by the foreigners tribunal, Assam, Borpeta 11th, in case number, this would find it page 38, within bracket BPT oblique 11th bracket close FT 1784 of 2017 is assailed in this requisition filed under Article 226 of the Constitution of India. By projecting that in the order, the father and the grandparents of the petitioner were declared to be a citizen of India, while the citizenship of the petitioner was doubted. The issue of this returnable in 4 weeks because the extra copies of the petition be served on the state and departmental council in course of the day. Next, pursuant to order dated 16/8/2023, our the understanding was for the Election Commission of India has produced the voters list of 1965, 1970, 1979, 1985 of village Bhandara, BHANDARA, Part Roman 3. Same is written on the record. Say what is this? The name of the grandparents of the petitioner. The voters list of just strike up the grandparents of the petitioner. Give up the stop. The voters list of 1965, the name of the grandparents. 65 and 70. 65, 70, also 79. These are whose names?
Grandfather,
Grandfather, grandmother.
grandmother, and in 65 and 70 also.
Hmm?
And in 79, petitioner's grandfather, grandmother, and father.
Achha. Then only two. So and so and 70. Name of the grandparents are not recorded in the voters list, whereas in the voters list of 1979, or the name of the grandparents and father of the petitioner is found recorded. And this Hazira Beba in this last page,
Yes, sir.
that is, who is she?
373.
Who is she?
Grandfather, grandmother.
Grandmother, okay. And what is the list of 1985, the name of the grandmother appears,
Father and mother.
along with the father and
It's
mother.
the last page.
Along with the father and mother of the petitioner. Next. With the records from the Tribunal court law. Next. In view of the interest made in the voters list, the petitioner is allowed to remain on to be allowed to go on bail on is punishing a bail bond of rupees 5,000 with one surety of like amount to the satisfaction of the jurisdictional superintendent of police, border, Bopeta. What are the conditions of grant of bail? It will be open to the said authority to obtain the fingerprints and biometrics of iris of the eyes recorded as a condition for grant of bail. It is also granted on the condition that the petitioner shall not leave the jurisdiction of Bopeta district without informing the court of place. List of documents.
Number 4.
Triangle. Yes, you are students of which college? Come here, come here. The students of which college? St. Joseph College. Where is that? In Nagaland. So you have come for court visits. Okay. Which year? Which semester students you are?
Third semester. Third semester.
Third semester. Okay. You have procedural laws. You have read procedural laws, CPC, CRPC, IBC, or
Yes.
MP?
SC.
What is it full form? No. You are in the college semester. I am asking you whether you have any opportunity to read procedural laws like CPC, CRPC. Have you, or Evidence Act? Have you read those? No. Okay, this was the proceedings then. Yes. Yes. Investigation of Dhubi Sadar PS case 271. Okay. Both sides are represented. All sides are duly represented. B. Sharma, additional senior government advocate, has prayed for further week's time to produce the updated status report of investigation of the Sadar PS case number 271 of 2023. This after 2 weeks.
Number 9. Then on the ground of minor discrepancies arise in respect of the age of the party and the picture itself. All the item documents were typically provisional on second page 123 legal opinion.
You see, your version was disbelieved because of your cross-examination. In the cross-examination, you could not satisfy the tribunal with regard to the name of your father.
Lord, whatever question put to me under section 164 evidence say, then I reply. It is page, my lord. Page 64, ma'am.
You come to the cross-examination, you did not say that father's correct name was.
Fajal Puri, ma'am. Fajal Puri, and Fajal. The sound is Fajal Puri, the sound is Fajal Puri. Now, we made the statement with a making statement that one and the same person. Page 64, my lord. Page 64, certain question to file and reply. Then I reply. What is your name?
Page.
Page 64, ma'am. So I said, what is the name of your father? I said, my father name is Fajal Puri. These are the questions to the other tribe. Now, we'll start.
Yes. We'll go to the LCR and examine it.
He relies on a voter list of 1965 of two Mukunda villages. And
I understand he doesn't have a land there. And he has stated that he has sold the land there, but that was not proved.
For the year 1965. My parents were residing in the Pumukon village till 1970. I made a statement, was a very pedagogical statement. In the 1970, they were shifted to Uttarakhand. So in 1971, I put the name of my parents. They are entering the voter list of 1971.
But these things are not to be proved by oral evidence. There must be something on record. Merely by making a statement.
One of the my agreement test. You are the exam and the PW2. You also said my did you also find page evidence of PW2 page 73.
No, Mr. Ahmed, it's a question of citizenship.
Yes, sir.
Supposing two people come and give evidence that Mr. Ahmed is from Europe, it doesn't make you a citizen of Europe.
So,
European Union, I'm sorry.
There was nobody could mention regarding nationality of the father.
No, that's why you see, when you are proving this citizenship, it must be based on something, because the names are so similar that it becomes very difficult. You pick and choose voter list of one village or another village, match the names, and then say that he is there. Then the mother names are different. What do you call it? The spellings are different. Not only the names.
And I respect the submit file. And because when the voter list of different grades, and I'm going to state this in my written statement, in my evidence, in the cross examination, as well as the other two cases that they examined. It clearly says my law that up to 1970.
You can go for the LCR. Let us examine that. Mr. Kiara Ahmed, counsel for the petitioner. Mr. G. Sharma, and it's respondent number
3 and 6.
3 and 6. Mr. L. David, and it's easy appearing for respondent number 1. Mr. B. Sharma, additional senior government advocate appearing for respondent number 5. So AI, Amit for respondent. To examine the case of the petitioner at the records. FT within bracket D, case number 291 of 2015. The requisition from the Foreigners Tribunal 3rd, Hojai, Shakadev Nagar. This is being called by the court, or it has been called by the by you? Support. Okay. List on. How much time? 4 weeks. To give bail on the same conditions, they will not give the jurisdiction of district of Vajra without informing the SP order. Vajra. This always right, if not already taken into custody. No, let the order be clear. Not taking into custody, then. Yes, Mr. Sarkar. Page 23.
August of 1965. This food for the fact and offense real number 147 and 140. Linkage is the father and which is my mother. 147 and 140.
But you see, your stand was rejected by the tribunal because it came to a finding that your majority would be in the year 1988, and therefore after that there is no explanation.
Admissibility was solemnized in the year 1987. Thereafter, Lordship with one who is a resident of Amsterdam. Thereafter, in the list of 1997, my name is for the first time entered in the list of from my
That is 2010. So therefore, you see, there is no explanation from 88 to 2010.
Is not there in the written
No?
in the inspection we have annexed to lordship. That's this 31 and 32.
Because you see, your linkage with your parents is not there
Yes.
in this case.
Lordship, my mother casted both with my father was in the voter list of in the year 1965, 1970, and lordship 1975. Lordship, along with my name was enrolled in the year 2010. What happened, lordship, after the death of my husband, lordship, I came to my father's home lordship, and recorded my name with my mother. Lordship. That is 29. Lordship. My name is recorded along with my mother. Lordship. Courtroom, who casted both along with my father in the voter list of 1965. And my mother name was also enrolled in the voter list of 1965. Case 29 86. Courtroom, 627 my mother and 630 present petitioner. And my mother also lordship reduced her evidence lordship before the tribunal and to wherein also lordship we claimed that petition except daughter. But her evidence is not believed lordship and that of the may be seen lordship. Case 21. Case 21 last
Just-
5
just
times.
one.
Last 5 times. Case 21 last 5 times.
Yes.
Copy examined Courtroom as eligible to because her age as 90 years and that copy Udupa alias Udupa is her daughter. She cast her both in the year 1966 with her husband in Tasset and her name appeared together in the of Exhibit 4 to Exhibit 6 with her daughter Udupa. Evidence of eligibility is not relied upon due to the measure doubt found in the portal. That a particular does not submitted other supporting documents in order to claim any documents except those portal list from Exhibit 4 to 6, which are insufficient and unlikely to come to the conclusion that copy is the daughter of Courtroom and
No, but where is the linkage of you with your mother?
Case 29. 29. Serial number 630. Same place, no shifting.
Okay. Call the records and grant bill because the linkage is there. Mr. 80 second. It's page 2 order dated so and so by group so and so. Bill to the satisfaction of Superintendent of Police, border government CEC will appear for respondent number 1 and 4. Election Commission will be number 2. additional senior government deputy for respondent 1. 5. So G Sharma for respondent 3 and 6. 87. We're continuing with the court taken into custody. Well,
Senior in the late option, he has been defrauded by number 5 person.
with the nature of transaction, is it with the nature of transaction, is it fraud or it is a monetary dispute? You say that the signature is of is a fraudulent signature, and the person who has given that signature is now bedridden.
In other order, he could have mentioned that he is not bedridden person.
Hmm?
In other orders, it was not mentioned that this.
Have you read the brief? I found some time yesterday to read it. Come to page 33. Shift over to page 34. Last 3 lines shows that he is bedridden, suffering from paralysis, and this is your document.
But in order to get
No, you see, this is a report of 28/5/21, page 33. Skip over to page 34. Last 3 lines. It is to note here that self tried to obtain signature of so and so and comparing the same from expert opinion, but the accused person is bedridden, half side paralysis, right side. I could not obtain the signature. So therefore, the only thing which you can do is to file a complaint case under 156(3) and proceed with the matter. If the investigation is not proceeding because it can't proceed, the police has given an explanation that why specimen signature could not be taken.
They are also not cooperating as revealed from the major leader at page 49.
49.
And I lost line of that. However, last line matter is not bottom.
Okay. This is some part of the story we are finding it very difficult. The checkbooks are with the accused person. How did the checkbook go to his place? How did he? Why did you not lodge any complaint? And it is your case that he provided all the materials for the construction. That assessment is not there. What construction? How much materials? How much materials were there in that house? Even the photograph of the incomplete house is not there.
Take care of cooperating in the legislation. It
Yes.
is also reflected in page 50 of the order of hospital management. Next one, please.
You see, checkbooks you don't keep in your house in the cloth line in front of your house, so that anybody can come just pick up that leaf of check and go out. It is your case somewhere in the complaint that you were very close with the accused persons. Accused came to your house and stole the checks. So is it possible that somebody would come into the house, steal the checks, take away, withdraw the money from that checks? You don't realize that the checks are lost. You don't lodge any protest. This part of the story we are finding it very difficult to say that there was a fraud committed. Hmm? Mhm.
Is there any case pending against the informant, competitioner? Any case under NI?
But Mr. Sharma, you see, these checks, as per the case of the petitioner, that 14 lakh some thousand was removed from her account. So the bank will have the check leaf as well as the specimen signature card of the petitioner. Did the police examine that and found out that it is not the signature of the petitioner? Was that done?
Let us pick my letter, I can take extraction.
Please take it. Please take it, because you see, the privacy, what is there? Somebody says that my check is fraudulently withdrawn. The bank specimen card is there. The signatures are there. The bank can say that the check signatures are tallying. So if on visual appearance it is tallying, it is a good honor by the bank. They are exonerated, because if it's quite a good match of the signature and the curvatures and all. So that is one part. But when the police finds that the man is suffering from paralysis, the accused person, his specific signature can't be taken, then obviously the police has these two documents to compare and say that this signature at least does not match. Because Mr. Sharma,
Deposited state pilot, company pilot. Says that spectrum matter.
therefore that is a lapse of one part of the police. You see, let us assume X has forged your signature. Correct. Now I catch hold of the accused person, and I tell him that you write the signature of Mr. Sharma. Obviously, I will not give the same signature. I will the accused X. He will change the signature. He knows not to match.
Perhaps my lord, to examine all these things, my lord, complainant was directed to be present before the IO.
No,
My
but
lord, they did not appear because.
No, but you see, the presence of the petitioner would not help the police. What is required is the check, signature on the check, and the.
Perhaps my lord, his cooperation is required. That is why my lord, he was asked to appear before the IO. That has not been done, my lord. My lord, they did not appear before the IO, in spite of my lord repeated requests. And now they are, my lord, seeking for CID investigation.
Where is the order of the court?
Order of the court, perfect. The report is 49. Report of that.
You have a copy of your statement of accounts? Is it annexed here? You have a copy of that with you? No, you see, this when you are holding a brief, it is a thumb rule that you should know it at the back of your hand. But if you don't do so, you're taking a great risk. Come to page 43, I'll show you the sequence. You see, I'm not supposed to read it, but I'm doing it because since you are holding a court, we must know some facts. And if you don't assist us, you don't expect any leniency from the court. 43, last para 2, 3. You see, this is a disbursement of 3 lakh rupees on account of so-and-so brick industry, right? Now you come to page 58. You see, in page 58, it says, reference to complaint of so-and-so, due diligence were not observed by the concerned officials during the sanction of so-and-so, the signature of the borrower request in respect of disbursement of 3 lakh. There is no record of borrower's mandatory request for such disposal and transfer. There is no record of voucher in respect of disposal of the 3 lakh. There is no signature of borrower on the voucher. So therefore, whether the amount of the 3 lakh was transferred, for that also you don't show that. The basic entry in your passbook that the amount has been taken away. And this is an email from the circle office to you, that is after inquiry. So your privacy story that the man was close to you, you gave him he assured you of getting you a loan. On getting the loan, you transferred 3 lakh rupees to him on account of bricks. Everything falls apart. And you are saying it is fraud. No, but you see, the preliminary things, when you are moving this code, preliminary things you have to establish. And it's a part of record that it is not true. Then there's a order of the court on record reflecting the statement by stand of the police that you are not cooperating. So we close the petition, giving you liberty to move to approach the police and cooperate with the investigation. We're closing this petition. We give you liberty to cooperate with the police. I don't know. Where is that?
Page 50 in the order passed and yeah.
Oh.
I will dispute it. I don't know my lord. Maybe there may be my even cases also. Maybe sir. Is the same circumstance of your lordship? Issue notices?
Huh? No point issuing notice and keeping it in court storage for 10 years. Then passing the same order which you are proposing to pass now. We'll give you time next week. Next time be thorough with your brief. If you permit me to read this brief, then things will go against you. So try at best you can, not permitting me to read it. Once I start reading, then things will go against you. Your name? R. Saha. On the prayer maintenance, R. Saha comes for the petitioner. just after a week, Mr. D. Sharma and the additional senior committee is present. You're there? MS C. Bora. D. Okay. You're for?
This is a panel.
Achha, and it's present. Yes, 13. Yes. Yes, Mr. Sharma. That be the case, then she is required to register herself. What to do? I understand. Yes. What do you say? No. She says that there was ought to be a direction to her to get herself registered with the competent authority. You want to take instructions, or we allow the petition? No. We are asking. You see, come to page 74. Last line says that she entered into the territory of India between 1166 and 71. So therefore, the next order should have been to get herself registered. What do you say? We allow the repetition at the motion stage, or you want to take instructions? Allowed to register. Okay. But we'll record your concession since we are allowing it in the motion stage. But Ms. D. Das, counsel for the petitioner, Mr. G. Sharma, and standing counsel for respondent number 4. And they will CC billing for respondent number 1 and 6. So B. Sharma will be comment advocate billing for additional senior comment advocate billing for respondent number 3. For SP border, Mr. G. for respondent 2 and 4. And so AI Ahmed, AI Ali, I'm sorry, study person for respondent number 5. Correct this repetition in Article 226 of the Constitution of India, the petitioner has received the order dated, opinion dated 31/5/2023, page 2, no? So and so. Let's go. In case of the petitioner, is that in the opinion, the learned tribunal had declared the petitioner to be a foreign national as her family had entered into the territory of the state of Assam in between 1/1/1966 to 25/3/1971. Accordingly, the case of the petitioner is that in view of the said categorical findings, the learned foreigners tribunal ought to have issued a direction to allow the petitioner to register her name before the what is the FRRO? Foreigners Regional Registration Office. In which place? Guwahati. As provided and required under Rule 19 of the Citizenship within bracket amendment bracket close rules of 2009. Within a specified period of 30 days from the date of rendition of the said opinion. Next paragraph. On a specific query of report, the learned standing counsel for the respondent 2 and 4 has submitted that for foreigners entering into the territory of India within 1966 to 25/3/1971, there is a provision under Rule 19 of the Citizenship within the amendment bracket close rules 2009. Again, get registered under the Foreigners Regional Registration Office. Let's go. As there is no objection to the claim of the petitioner that the learned foreigners tribunal had omitted to allow her to register herself before the regional registration office from Kolkata. It's not being disputed at the bar by the counsel appealing for the respondents. The court is inclined to allow this petition at the petition stage without objections or notice on the respondents by allowing the petitioner, namely so-and-so, alias so-and-so, the proceeding in 50 case number so-and-so, old and new, now bearing reference REF, 50 case number 519 of 2009. It is at page 2. To get herself registered before the foreigners regional registration office within a period of 30 days from today, in terms of the provisions of Rule 19, of the Citizenship within the Amendment Rules, 2009. Persistence, and not to the extent is indicated. Should be more addressed first.
So, withdraw her voter ID. Or voting rights may be cut. 10 years later.
Okay. Just back to that. It would be open to the competent authorities. On such registration of the petitioner in the Foreigners Regional Registration Office to curtail the voting rights of the petitioner for a period of 10 years, and to withdraw the recall or to present the voter ID card and corresponding deletion of the names from the voters list for the prescribed period of 10 years. Next, the petitioner shall produce a certified copy of the order before the Foreigners Regional Registration Office, surrender her voter identity card before the set appointment.
Okay.
This can't be read. That is why this was discarded. Mr. Sharma, and you can please take a look at this document. The tribunal has rejected this in its opinion that this is not readable. I am a spectacle person. I can read. So what do we do? Last name is Anita, second name is Jayanti, first name is so and so. It is faded. Yeah, without a spectacle, you also can read. I am a spectacle person, I can read. What to do with the tribunal? I can't read. There must be some answer. And what is the law that if an original document is produced from an authority, is it required that the person issuing it must come and exhibit? Because I have used for a different reason. This is, you see, this is not a document which is a which is otherwise inadmissible. Foreigner's registration certificate issued by the border while the person is entering into the state is a state document. Is it not? Is it unbelievable that the executing authority must come and prove it? What is the law in foreigners tribunal? I am not aware. Huh? No, I don't know the law. Since you are the petitioner, we take the privilege of asking the government advocate. No, you see, it's not that. It is rejected. That you find in the opinion somewhere at the relevant page in the last part, page 5. That is rejected because not readable. So asking for opinion will not change it. If one doesn't want to read it, then it can't be readable. If I don't want to read it, nobody on earth can push me to read it. Even if it is legible, I'll say it is not legible. I can't read it. End of the matter. Supposing I want to adjourn the matter today, I just say it is not readable. No, but if the tribunal doesn't want to read it, how shall I make it read? No, authenticity is not disputed. It says, you see, nowhere it is written the authenticity I am disputing. It says I am rejecting because the issuing authority has not come and proved it. Number one. That is why I am asking you the question that what is the law in foreigners tribunal cases? Is the author required to come and prove it?
Yes.
Has to come and prove it. Under which provision of the Evidence Act? No, because I am thinking aloud. Let us say there are 10,000 civil cases pending in the entire state of Assam. In all these 10,000 cases, the right title interest is under challenge. Therefore, the deputy commissioner will have to run all the district deputy commissioners in the state who are issuing pata. We will have to run from one court to another to prove the title of the person. Assuming somebody questions my appointment, then none else but the highest authority of the country will have to come and depose. Supposing you issue a quo warranto against me, you question my my office. Supposing you do it, you have a right to do it. You may do it, you may not do it. Supposing you challenge by a writ of quo warranto my position, and I'm just thinking about how many people will have to come. Highest authority of the state, highest authority of the of the union and highest authority of this court, 3 people have to come and depose. Please take it, because this is something, if it's an original document, I'm in possession of it. Correctness is not disputed. If you say in your written statement, yes, I dispute this correctness, then the burden is on the burden was always on me, but the onus will also shift to show it. Because you will come with and say that the original register doesn't have that entry. And if that is not disputed, somebody just questions that you are not a graduate, somebody will have to now call for the authorities from Board of Secondary Education, Assam, Guwahati University, Calcutta University. Somebody must have got a degree from Cambridge, UK. So the authority of that university will have to come and depose. Just think of the anarchy which will prevail. Just somebody has to question the degree from Cambridge University. So just raise a dispute, fake degree. And then now I have to call witness from Cambridge. At 2 o'clock. Please see, because I am not aware of the process. I'll be guided by you only. And I'll tell you why. This is something I always I'm amused, and I always refer to this. Interestingly, we two are the only people in the country, along with other brothers and sisters, who are exempted from doing law. For average person, ignorance of law is no excuse. But for both of us, ignorance of law is an excuse. And that is why I said that I do not know the law. You see, come to 57. Facts for which the court must take judicial notice. Correct. Turn over the page. There are 13 facts of which the court has to take notice. Then I have tick mark with pencil. Last. Yes, so that's why I said that I don't know. Now you'll have to produce books and show it to me that this is how original documents are exhibited. Because you see, title deed, the sale deed I am having. And the sale deed I can prove it of my own. It is only when the vendor comes and says that this is not my signature, then I have to prove through other cogent evidence the signature of the vendor. But otherwise, it's a title deed. I am owner of a title deed. Nobody has to come and prove it in ordinary circumstances. So in every case, you see somebody says that I have passed out my metric in 65, and you will say that call the SEVA and then prove it. Why an original document has to be proved, and the correctness is not disputed. That is the basic question I'm asking you. At 2 o'clock, okay. 15. Yes. Where is the opinion? Which page?
Opinion will start to page 15.
15.
And we need to put some numbers in the page 7. It's 7 you are looking to find. There are 15. Indicated through the proceedings and evidence produced by a client is to establish that the lineage of the property has been continuously residing in Indian soil since before March 1970. The determining factor only relates to the not proving of any of the activities duly and exhibited by him, although verified in his defense to establish himself as an Indian citizen. What has been meant? I had exhibited my 5 number of documents, which what you will find.
Yes.
From 3 to 44, lecture 6. These documents matter, although I have exhibited matter. I am not called for the authorities issuing the documents before the court to prove this. On the basis of that matter, I think that there. Now, another aspect I would like to bring to your lordship matter. What has been matter after I have submitted these documents? The learned member has already also sent for authentication of these documents for the authority. All the 5 documents they were authenticated and they were proved to be genuine. These documents on page 44 LFS 6. Firstly, is the service certificate of my father. He was working in a
Which is the document? Page?
page 44, exercise 6.
Yes.
This is the service certificate of my father. He had worked with a Khalasi member under 6 your lordship will find period of service from 10/9/48 to 28/2/1982. This certificate was issued in the year of 1984. This certificate was also they have authenticated member. It was complete true. And next your lordship will find member. Mr. 7 member. Is 46 member. That is the voter list in relation to my family. 1970. There are also member. My father's name member. Minda Lal Day. This year is member. From member 151 Joyful LSC member in the year 1970.
Yes.
Thereafter, my lord, for replacement, I had submitted the firstly the happy card papers. That is annexer 8 number 47. My name is Son, my lord. Samir De, son, daughter of son of Sri Manindra Lal De. Here also my age, my lord, in years is also shown. That is 15 years, 5 months and 29 days.
Yes.
Next is the my past certificate, my lord. I passed the SLHC in the year 1979. There is annexer 9, my lord, case 48. Thereafter, my lord. There is annexer 10, my lord.
Just a minute. Mr. Sharma, you see, accepting the submissions of Mr. S. Parashar, taking the submission of the Mr. Parashar at face value, you're not saying whether he is right or wrong. You're just accepting it for the face value. 5 documents, he says, were authenticated by the tribunal. And that is not disputed because in the opinion that has been reflected. Now the court is discarding that document by saying that although the documents are authenticated by the tribunal, but he did not prove it.
Yes.
And therefore rejected.
Yes.
How is that possible? If the court calls for a document which is authenticated, then it is discarded just because he has not proved it. That's something irreconcilable. I don't find it acceptable. Then why did the tribunal in the first place authenticate it? Once you see power of the court under 165 Evidence Act is unparalleled. It can do anything. But can evidence which has come on record be discarded because somebody has not proved it? What happens to the power exercised with the tribunal? It has done an act. Can that act be washed away? It is not the petitioner who has failed in proving it. It is the tribunal who took upon itself the pleasure of having those documents authenticated. Now it is authenticated at the desire of the tribunal. What happens to the velocity of or the proof which is created by the court itself? Tribunal, in fact, not the court, tribunal. Tribunal creates an evidence in form of authentication. How that proof can be washed away? Unless you have this Evidence Laundry Act, you have Money Laundering Act, where money is laundered. Laundered means it is washed away and made good. You know that, huh? You know the principle of Money Laundering Act. Laundry is something which is washing. Therefore, by a chain of series of transactions, bad money is made good. That is laundry. So in our country, do we have the Evidence Laundry Act? That the court creates an evidence and that can be washed away by taking any presumption that it is not proved. No, you see, because this Mr. Sharma is, although I'm saying it, making it look very light, but it's very serious. You see, somebody comes to court, alleges before the court that he has been beaten up by the police. We ask for a report, and in the police report, it comes that yes, he was assaulted by one policeman when in lockup. And then we proceed to hear the matter. Can the state now say that, well, you asked it and we gave it, but the petitioner has not proved that he has been assaulted? Let him give evidence that he was assaulted. Can the state turn around and say that, discarding the evidence of its own report? Can that be allowed? Because had I not been here, I would have been the happiest person. You see, there is under Order 26 Rule 9, there is a Amin Commission report. An Amin Commission report will discard it just because it's a basic onus is on the plaintiff to prove it, or the defendant who has got this Amin Commission report to prove it. The question is that what happens to that Amin Commission report? That is why CPC says under Order 26 Rule 10, 2, that an Amin Commission report is an evidence. So I go by the same civil principles that once a report is there, authenticating a document, it becomes an evidence. Principle of Order 26 to 10 applies. Where is the court? I'll show you something. You see, 165 proviso. First is power of the court, then there's a proviso, 2 lines only. Read that. After the first paragraph of 61 provided, please read that.
Provided the judgment must be based upon facts declared by this act to be relevant and duly proved. Provided also that this section shall not authorize.
No, that is not required. Only the first part. Now you come to section 5. Section 3, sorry, interpretation clause. Section 3. First page you will find of the book. Yes, 3 facts. You got it?
Interpretation of clause.
Facts. perceived. So therefore, when the court itself calls for a report and it is authenticated, it becomes a fact, and then you will find next is fact in issue. There's one after facts. There's one more, and then facts in issue.
The expression section is mentioned into any text from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily close.
So see, when the court calls for an evidence and it is authenticated, it becomes a not only a fact under the interpretation clause, but it's also a fact in issue. And therefore, read its proviso to 165. We say that if it is otherwise fact in issue and determined by the court, so the chain is complete. It is a fact which is proved not by the party, but by the tribunal itself by calling for a report. That evidence I don't find, and you need to wash it away. Yeah. I've already given one of the same mistake. That's Parashar for the petition. Study CCC for responding 1 and 4. So G. Sharma, Government Deputy to respond to 2 and 6. So B. Sharma, Senior Government Deputy to respond to 5. Election Commission is AI. Respond to 3. So mail 5,000. The satisfaction of SP border. Explain. Just a moment.
Petitioner gave to the tribunal a written statement with the document evidence and used her father and release statement of her maternal relation. Order starts from page number 27.
Just a moment. Just a moment. Where is the notice given to you? But that is relevant. You see, page 31. Third line is the inquiry officer's report dated so and so, form so and so. Father's name, OP was mentioned as late Abdul Sattar.
Yes.
So therefore, notices must, if you are not shown that notice, how will I understand your linkage? Because the tribunal has rejected your linkage with your father.
In my W's, I have written this. Sport verification was not done by the inquiry officer. My W's start from 3
Page 33.
Yes, 33. Inquiry officer just come to the sport and the sport verification was not done.
Where is that? Where you have stated that? Which paragraph?
Paragraph number 4, page number 34. Start from 34. The entire inquiry report prepared by the inquiry officer, Mr. Padmakanta Vora, is also to the unsity of the report. Honorable Tribunal may kindly please call on the inquiry officer to examine the pattern.
Now you understand where you stand. These two lines will make you understand why where you stand. First two lines. Read again.
The entire inquiry report is prepared by the inquiry officer. Mr. Padmakanta Boda is false.
OP will prove. So you have taken upon yourself to prove that the report is
Yes,
false.
In para number 5, it is also talking about the inquiry.
Yes.
And worship only use page number 37, para number 9. Mary Dolo.
Just a moment. Page 36. Yes, Mr. Sharma. Mr. Sharma, just we have to issue notice and then stay the give him a bail. You say I'll show you. I'll show you the reasons. Come to page 30. Last paragraph. Mohammad Achar Ali, who the OP claims their father is deposed. Correct. So his father is this. Page 30, last paragraph. Correct. Now you come to this para 7 of the written statement, page 36. He says that the inquiry, his father's name is shown as Abdul Sattar. Where is the office begs to state that Abdul Sattar is our uncle. So therefore, the tribunal has discarded the evidence of the petitioner just because in the report 1, 2, and 3 form, his father's name is shown as Abdul Sattar. So his plea was never considered. So it is Mr.
F.A. Bobia.
F.A. Bobia for the petitioner. The DVCs for respondent 1 and 6. Election Commission will decide Ali, respondent 2. He's in custody. No. No, but in the judgment is to be given as
Kept in detention. Didn't get the procedure. We kept in the control centers.
see page 32, you are in detention.
She was not in custody. She is outside.
So election commission, respondent 2. G. Sharma, strategy for home development will correspond to 3 and 5. So B. Sharma, the will correspond to 4. Similarly, satisfaction of
SP border solid.
active, SP border solid door. Okay.
And then
Yes, Mr. Ali.
Schedule document with one. I brought with 70 and with a 70 would be 92 totally, including the petitioner name as well as certificate. And our certificate and only
How will you prove the linkage?
minor here is only manner next which is 5.
Page
65.
65.
Yes. Cell number 3. Here, other both for the other expected that my data and the post examination. Other also and BW2 and now we have the name record.
Shows this 1965 and that's
And
65 and 70 or 71. Show us that. Which page? Which page? 22.
Yes, madam. And the other that's 23. Normal.
What is the name of your grandfather? No, this is 85, not 85. 65 and 70. 20.
And 65, then 65, particular 19, and this is particular 15.
Now, how you shown the linkage with your grandfather?
Next, 85. My name is my father.
85.
Yes, ma'am. The same reason, madam. No.
Which page?
This will 23, madam. Mother.
23.
Next, 19.
No, no, no. You see, this is your father is Muhammad Ali,
Yes, ma'am.
but here the father's name is Abdullah.
My grandfather.
No, no, but page 20 you are showing is some other name, Ahid Ali.
Father is grandfather.
No, no. Ahid Ali and Ahidullah are different names.
Same, my lord. Sometimes it's Ahadullah, sometimes Ahad.
That is the great difficulty.
That is my grandfather name is some.
No, but how you have shown that these are the two names of the same person?
I'm not the
Your affidavit will not do.
Manikwas, my lord. Ahad, my lord, can you see Manikwas, my lord? Ahad Ali.
No, no, you see,
And
it's very
for
simple.
current
No, no,
yours, Ahad.
no, Mr. Ali, you see, I get a cause list in the morning.
Yes, ma'am.
I pick up one name here. First name is S. Sutradhara in this cause list, lawyer for the petitioner. Last name I take up, it is Miss U. Hazarika. This is the last name they call it. And I say that these two are same person. They are typing mistake, writing mistake. This one place it is written as Mr. Sutradhar. In the second place it is written as Miss U Hazarika. They are two and one and same person. I give this affidavit. The question is that the person who is
father's name, my lord, Bandesh are similar. Bandesh Ali,
where is that page?
My lord, 65 voter list, my lord. Page 2019, my lord.
Page 19.
Yes, ma'am. Date given, father.
Bande Ali. Yes.
70 and 60 my lord, right, and 70 my lord, Bandesh.
Page.
Page, my lord, 21.
Page 21.
Yes.
Bande Ali. Okay. Same village.
Same village. What father's name of the same village?
Okay, they will issue a notice and then give him bail.
Only Usman Lordship case 37.
37.
Just like here. So, Puriela Pra, Zonata, Yogan, Murika, Murabari, and Umber, Lucky, Abdul Barrett, Ustra, after the Papa. Only that artist. And was Lordship.
This person came and deposed. Did this person come and depose? No.
Other
Huh?
other and Lordship regarding other claim, his name was not along with his. How will not other? That the time and voter not enrolled with other. How will others name?
No, but the independent of each other, if otherwise the names match. Examine it. If it is in the same village, names are there, then perhaps it's made of the case that maybe there's a wrong entry, the grandfather's name. Mother is dictator for the same for instance, same child for the petitioner. The CC for response number 1 and 4. AI study muscle for election response number 2. G. Sharma, government review for response number 3 and 6. So B. Sharma, additional senior government review for response number 5. Still about to be 5,000. Supreme satisfaction window police order Morika. If not already taken into custody. Tribunal record secretary.
For admission.
Yes.
Imposition of brother, but when considered a single word of this very concerned. And the imposition of husband was also not mentioned as well as
Where is the opinion? Page
39.
Mr. Ahmed, in your evidence, you not introduced anything to show that your entry or your birth in the country is prior to 71, and that your parents they had any document to show that admissible documents.
The total list of 65 or 70 that is correct. But the deposition of the own brother, his name was also enlisted in the total list of that was also accepted. And regarding the deposition of own brother, nothing has been described. And regarding the deposition of our own husband, who is also a resident of the adjacent village, nothing has been described.
No, by all evidence, you can't prove citizenship. There must be some document to say that three people coming in and saying that he is a resident of this village doesn't make one citizen prior to 20 September 71.
This lady is available. She got married prior to hitting the age of maturity. Therefore,
No, we are not questioning that. But you see, the linkage must be there from someone who is in the country from prior to 71. That
only
you
on the
failed.
basis of moral evidence of the own brother and the husband, which were not given as the resident. That part should have been considered by the
You see, husband's evidence will not show parentage.
That is true, madam, but he is also a resident of the adjacent village.
You don't get the point. You see, he must have seen someone in the country prior to 71. That is not his case. Even if I come to that witness box and depose that I know Mr. Hamad, it is not a proof of your birth or your linkage prior to 1971. That is something which can be only demonstrated on documents.
On the basis of a copy, is the land document. So, issued in 1973, they were the father of the mother.
Where is that? Which exhibit?
It was exhibit.
No, which exhibit number?
Page number 20.
It's a Jamabandi.
Exhibit E.
Exhibit E.
Exhibit E.
So this is not a proof of something which occurred prior to 71.
Not prior to 71, but it is a document of 1973 because after the death of the grandfather of the petitioner, and father immigrated this particular land. The name is there. The left side, serial number 2. Serial number 3 is the father. Grandfather is Hussein. That is there.
No, but you see, this exhibit is not a proof of document.
If can be compared with the 2016 in this particular document, should kindly compare this document with the voter list of 2016. That will not be page 17. 2016, I am referring to this voter list. The name of and the brother of the petitioner group. Other number is other name is also there after the question. Therefore, there is a matter civil. His deposition is also.
No, we can't accept it for a simple reason. And you know that it's a case where the reference was made in the year 1998. Correct. So, and the father's tribunal case was registered in 2015. Therefore, entries made in 2016. The post reference being made, it's very hard to accept it as a proof.
This petitioner may be given as last chance to produce the voter list and this will be with her parents. Since
But then you have to file something, you see.
Otherwise,
No, continue, Mr. Ahmed. The problem is rather the factor which binds us is a legal principle. A demand just cannot be made to enable you to release some evidence. You must introduce something in the in this writ petition which entitles you to an order of demand, because order of demand cannot be on the drop of the hat.
May I pay for a motion that I may, by finding of an additional effective, I may be getting some federal before the Supreme Court.
To do it, because otherwise you are not satisfied. For an order of demand, you must make out a case that there's something which calls for a demand. Such a to be presented. The prayer made by Mr. E. Ahmed, counsel for the Z. Ahmed, the counsel for the matters adjourned today. We are not saying anything in the order. The final application. No, because that must be considered not as an order of the court. You must place it in your own record. We're not saying anything, but you can do so because this is, you see, your right to file an additional affidavit is not cannot be curtailed by a judicial order of the court. I can't say today that you may file or you may not file. Please, doctor. 2 weeks.
For some reference to what are the reference was without that also we are in a position to argue. Without that also we are in a position to argue that should put up
But the judicial order is there in compliance of this judicial order. Possibly that is not there.
What has happened in this case? The remarks of the petitioner is that they are doing a salary pay up at the gateway of 7,400. They want it to be 8,700. Honorable Court has guided me to get the pay slips where people are being paid 8,700. They are not being paid under it.
No. That is not our pay. 8,700.
Yes, we do.
Just a moment.
Just trying to trace out.
No, it doesn't say this. This order merely says, order 22.8 merely says, I'll tell you, Mr. R. Mazumdar, standing also for Elementary Education Department, submits that even in the ME schools, other than science teachers, the teachers having graduate degree as qualification are being paid grade pay of ₹7,400 only. Mr. Mazumdar shall keep relevant pay slips available for the perusal of the court on the next day. So it doesn't say you produce the negative, because that can't be a judicial order to produce the negative.
Those cases I have read.
It's there.
Here in the finance department, Mr. Vigo Boy appears. He is under medical leave. If a short accommodation, people can review office from Monday. So update can be this.
Okay. Just to understand the issue, the petitioner claims that they are entitled to graduate scale. What do you call grade pay? Being a graduate, your standard of the state is that the graduation is a minimum qualification, and therefore, if they are having, they are not entitled to any other incentives.
What we say is that their entry level qualification is intermediate. Therefore, they are not entitled to the register. The ratio with the register. That is what we say.
So agree to a date when
Any date after Monday.
and you will produce that.
Yes, sir,
Fix it on Wednesday then. outside the duly represented. Mr. Yes, your
My lord,
presence is
I had
recorded.
given an undertaking before we could. My lord was there. That if they can produce those payslips, wherein the ME school teachers, graduate teachers, are getting 7,400, then I'd have no grievance. I'll be trying.
He produce it. He says that
Will he produce it?
he says he will produce it, but today Mr. Gogoi is seeking a leave. Mr. Gogoi is medically indisposed.
When is
Wednesday we are fixing it.
I don't understand, my lord, after the pay commission has given certain grades, how can an executive under 309 rule, how can an executive go beyond that? It's a 309 rule. I'm taking their stand. Say that category A.
We'll give you an
category B,
opportunity.
category C.
We'll give you an opportunity to understand.
That's what I'm eagerly waiting for. That's why I keep running. You produce something. My lord is having a bit.
What says the duly represented? On behalf of the Finance Department, Mr. A. Shadia, Standing Counsel, submits that the Mr. B. Gogoi, counsel holding the brief, is indisposed and accordingly prays for a shorter adjournment. It is allowed. Next one. As agreed to by all sides, list on 13/9/2023.
He'll produce the one of latest cases, not the one, because there was a time in between where WP message they had stopped. So he'll produce the latest ones. That's only I'm saying.
No, latest means according to you, what will be latest?
The latest means, my lord, when after the pay commission report had come, they had accepted 8,700.
No,
My
give
lord,
the
they
time.
said after 2017 or no, after 2019, they left it.
After 2019, yes.
Whatever I have on record, I got it.
I have those papers now. I also.
Mr. Mazumdar, you have understood what is not written? Correct. 2019 onwards, that is what he is asking.
Because when after the pay commission report had come, they had accepted it 8,700. They issued a WT message saying that don't pay. That was put to challenge. That period, they were paying 7,400. That was put to challenge. This honorable court set aside that. Then they might not amended the what do you call that, the pay commission report. And any school was made 7,700.
No, pay commission report, they don't amend, they will not accept that part.
No, they accepted it. They accepted 8,700 for all. LPME. Thereafter, they issued a, what do you call that, a WT message. Stopping this. That was put to challenge before this honorable court. That 309 rule, you cannot stop it by way of an executive. That WT message was set aside. Thereafter, they amended the pay commission report, or the acceptance of the pay commission report.
So acceptance will
The
be
acceptance of the pay
acceptance
commission
only.
report. And interestingly here, they continued with 8,700 for the ME school, whereas made it 7,400 for LP school.
22.
Yes, 22. There is an inquiry report here. Huh? Court was not satisfied with this report. Yes. Okay. Also, the duty represented, Mr. G. Sharma, Leonard, standing counsel for the Home Department, placed for some more time to comply with the order dated 26/7/2023. Since I jumped the list on when after 2 weeks, give a date. 2020 matter.
25/9. Twenty-three.
Near 3 months, 4 weeks and 5 months.
4 weeks in a 2020 matter.
He's not
Uthare is here. This was not.
Okay. Okay. Mr. Akini Chaudhary, DSGI for the petitioners, and Ms. Udas, Land Council for the respondent. Next one. The Land Council for the respondent, case for is granted for weeks time to file affidavit in opposition to the matter. List after credits.
Twenty-four.
No additional affidavit is filed in terms of last order. You have any document to show that the names of the parties appeared in the voters list of 1985? No, here it says Mr. Here, here. Mr. A. Ah, yes. You need some more time. How much? 1 week. Okay. Will you give that? Okay. All sides are duly represented. On behalf of Election Commission of India, Mr. T. Pegu, and council pays for some pays for 1 week further time to take necessary steps in terms of order dated 17/8/2023. As adjourned today, based on the date.
18/9. Twenty-five.
have the order dated 27th of
Admission register. You're for education department.
directives to produce some documents for shifting of the shifting. I have collected some land documents. I will allow to produce.
Non-counsel for the petitioner pays for some time to file an additional affidavit to bring on the what the proof of shifting from one village to another. Phase 1 is granted. Next, Miss B data, then standing person for the limited education department. Phase 1 is granted for the time to produce the admission register in original of the concerned LP school is referred in the order dated 21/7/2023. How much time? How much time? You can fix it tomorrow if you want.
No, no, not.
Then tell us when. There's a calendar in front of you. Put up a new calendar there. No? 28th September. Okay. 28th is Thursday, make it 29th. You're giving me one day more. This one 29/9/2023. Continue to yes 14. Yes.
And last. This time.
Mr. Sharma, how does it help you? This observation?
Describe that documentary evidence will have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing, and proof of content is another. Not only the document will have to be proved, but its content will also have to be proved. Therefore, the truthfulness of the contents of the document will also have to be established from the record. Lordship, it is apart from that, Lordship, it is a post 71.
No, we have heard you, but how does this paragraph help you? Was this principle applied in this case?
Yes,
So reject the document.
he submitted this document, Lordship, before the tribunal, and one of the tribunal has Lordship.
Page.
Yes, yes, right. 91 Lordship.
Yes.
On version of exhibit A, it is noticed that document is not legible, and most of the writings are washed out. Finally, document is not proved through this.
No, but you have seen the document.
Yes, Lordship. It is legible, but this document.
No, if it is legible, how can a legible document be made illegible and discarded?
Otherwise, it is a post.
No, you see, no, you see, it is whatever statement I am making is subject to explanation by you. You can make a better submission and convince us. You see, what is the principle of giving evidence and cross-examination? You forget this tribunal business. Let us state you take any other tribunal except for foreigner's case. Let us say debt recovery tribunal. Debt recovery tribunal, somebody, the bank comes and files a case, and it says that this is my sanction letter. Exhibit A is the sanction letter, and Exhibit B is the statement of accounts. Here's overdue account of amount of X. Exhibit C is the demand notice, and that is not paid, and therefore my claim. That is the simple case of the bank. Now, we take the statement which you have, this order which you are showing. Evidence would have to be proved on the basis of record. Now, sanction letter is a record. The bank's officer comes and proves it. It's a matter of record. Now, let us assume that in this sanction letter there are a few things which are left blank. There are blanks, there are erasures. Now, if a sanction letter, say, let us say the loan was of ₹1,000, and that ₹1,000 is not written in the sanction letter, but in the statement of account, which is proved, the entry of ₹1,000 into the account of the borrower is reflected. So, does a omission in this sanction letter will take away the claim of the bank? Why? Because you see the principle which you are relying on, document evidence must be proved on the basis of record, and the contemporaneous record must sufficiently prove the contents. So here, both these three things are absent. All the three things. The record does not have the sanction amount, so therefore, it's not based on record, and thus the contents of the document is also not what is the loan amount. But you see that there is a bank passbook or the entry in the bank statement of accounts. The statement of account establishes that 1,000 rupees was transferred to the account. And when a demand is made, it is said that you took, on so and so date you took a loan of 1,000 and therefore there is a demand made. Correctness of that is not denied. Now, let us say an objection is raised in this case that Exhibit A is not admissible because it contains omission. If that stand is taken, then the bank has a option available to it to bring additional evidence and to cure that defect. But in foreigners cases, what is happening during the stage of trial, there is no objection raised to the admissibility of any document. I have not seen a case in foreign tribunal where the government advocate or the by whatever rank you call him raises any credible objection with regard to the admissibility of any evidence. So the proceeding is unable to rectify any of the defects which is there. And in the judgment, it is written that this is not proof, that is not proof. This was discarded only on the ground that it can't be read. Now you see, I told you I could read it. My sister could read it. You also could read that document. So a document which is otherwise readable by all three of us is being rejected by the tribunal. It's not readable. Now, what is the? How do I treat that circumstances? It's almost like a plea of insanity in a criminal case. Somebody says that no, now it's an amnesty case. What do you call? You will find this. Well, I've seen that. When you are in the court campus and look at people, you will find a healthy man walking in. And in the court, when he goes to give evidence about his injury, he can't walk, he can't stand straight. He needs to support. And after the evidence is tendered about his illness, then you find him running down the stairs and walking away, sprinting. Correct. So it's just like that. I don't want to read it, therefore I say it is not readable. You have seen the document. Yes. If it is not readable, can anyone, at least three of us are examined. Nobody said that it can't be readable. So therefore this principle you are showing us, proof of document and proof of contents. You satisfy on the legal principles because if you're not satisfied, the correct legal principles are invoked. Because a readable document is made unreadable. It is almost like looking at that watch behind you and saying that no, it is 4:30, I am rising. You all say that no, it's not, it's only 2:10. Our matters are there listed in the court. And I said, no, I am getting it 4:30, I am rising. My day is ended, 4:30. So if I do that, what is the remedy available? As a court, if I read 2:10 as 4:30 and rise, if we do so today, what will you call us? Very politely, you could have you will say that there's some flip in the mind. You want to say it very politely. Mr. Chaudhary would have a good word. Because this is very serious. If a document readable, you see, in your group, one of the neutral men is Mr. Sharma. Mr. Sharma, look at this document. Court, the tribunal says it is not readable, but I can read all the three names. It is fate, but I can read it. Correct. One is Suniti or something. The other is, third name is something. I can read it. Left side, yes, this one. It is fate, but you can read it. With some stress, you can read it. No, that's what I said. With some stress, you can read it. It's not that it is not readable. It is, you say, old document, it may be fate. It may be fate, but it's not readable. Not readable is something we are unable to accept. Will issue notice and give him bail in the meantime. Say what?
Document was issued on 21 till 1971.
Oh, correct, but somebody is entered and that entry is made here. Can this be discarded on that ground?
Yes.
Can it be discarded? The registration of the foreigner at the check gate in 1971 can't be discarded because of that. It's about to take it from. No. Mr. AMS Muzunga wants to do petitioner. LDV, CC for respondent number 1 and 3. So, D. Sharma, Business Senior Commercial Officer, appearing for respondent number 2. You are 5. Okay, he is for 5. Mr. G. Sharma, standing for Home Department, appearing for respondent 2 and 6. Mr. AI Ali, standing for respondent 4. So, what is the bail 5,000 to the satisfaction of Superintendent of Police, Border Kachar. From this point.
Number 4.
Not 13. Based on 13, 9/2023 as paid for by the Constable Petitioner. Mr. Matt, yesterday the petition person expressed some explanation that there may be some contents which should be in camera. So we propose, we are of the view that we'll take it up as a last matter so that the court is empty by then, and then we take up the matter so that she's not embarrassed.
No, your lordship, you can take it now.
You can take it up.
Yes, you can take it now. I will have it.
Okay.